Welcome to the knowledge sharing initiative of our firm. Today we'll be discussing about the annual performance report under FEMA, and we'll be discussing about the background, its applicability, what are the reporting requirements, and we'll also discuss some most commonly asked questions which have become kind of a confusion for many, especially because there have been new rules, new directions, new regulations that govern the overseas investment framework. APR typically applies to all Indian entities and resident individuals, which are persons resident in India who have made an overseas direct investment. The timeline for this reporting is the 31st of December. So, for all entities that have made overseas direct investment, they are required to file Form APR by the 31st of December. The format of Form APR is given in Annex 2 of the Master Direction for Reporting. The reporting requirement under the APR is typically about the overseas entity, that's the foreign entity. The Indian entity or the resident individual, while filing Form APR, has to report one, the change in any shareholding pattern of the foreign entity, the change in the financial position of the foreign entity, the repatriation, if any, that has been received by the Indian investor from the foreign entity, and any onwards investments that have been made by the foreign entity, which is technically called a step down subsidiary. The first commonly asked question is about the reporting period. So, if the investment is made in June of 2023, would APR be required to be filed by 31st December? Technically, the first reporting period of the foreign entity would not have ended by 31st December, and that would essentially not have a reporting requirement cast this year. For example, if the first investment is made in June 23, then typically the first APR would apply from the next year. So if the first before the first year end, if 31st December 2023 has come, there should not be any reporting. What happens about December year end? So, for example, if this entity itself, which has been incorporated in June, has to close its financial statements in its host country by the 31st of December 2023, which means that that's the reporting period. So that coincides also with the APR reporting period in India. However, the clarification is that if the entity closes its financial statements on 31st of December, then APR reporting is 1 year deferred, which means that for this entity, its first year would be June to December 23, APR for which would be due by 31st December 24. Similarly, right now, by 31st December, all entities that have financial year overseas ending on December 31, 22 are required to file by 31st December 23. What happens in the disinvestment year? Disinvestment in FEMA refers to the alienation of shares or the interest by the Indian entity or the resident individual. When this disinvestment happens, typically up to the date of disinvestment, you would file the APR. Also, up to on the date of disinvestment, you would file Form FC for reporting the disinvestment, and that would absolve you from filing the APR. In the case of liquidation, up to the date of liquidation, you would be filing Form APR, that is up to the date of initiation of the liquidation, and then on receipt of the proceeds of liquidation, you would file Form FC. And there's one specific exemption given for instances where control does not exist, but it is coupled with a condition of 10% shareholding, which means that if you do not have control, you should also not have 10% shareholding. So, in instances where both of these conditions are met, that your shareholding is less than 10% and you do not have control, you would be absolved from the responsibility of filing Form APR. However, there's one specific nuance that we had the opportunity to discuss was that if the company is incorporated in, say, calendar year 2022, and the bank account opened in somewhere Jan or Feb of 23, and the first remittance happened afterwards of opening of the bank account of the foreign entity, would this entity, would the Indian party, or sorry, the Indian entity or the resident individual in this case be required to file Form APR? In our discussion with the AD Bank and a clarification that they got from the RBI, typically the reporting applies only once the outward remittance is made by the Indian entity or the resident individual, as the case may be. So incorporation of the foreign entity without any activity is not the determining factor for reporting in Form APR. This year, the biggest question that has come is whether audited financial statements are required for all foreign entities. Where there's so what we have done is we have tried to make a simplified flowchart for this. So the first question that you need to ask is whether control exists or not. You know, the requirement of host country having audit mandatory or optional, all of that is secondary. The first question that needs to be asked is whether control is there, and control has to be looked as per the definition given in the OI rules and not as per any other definition. And control for the OI rules is different from the concept of place of effective management under international tax. So control as per the OI rules typically involves the power to appoint all the directors, and also, sorry, majority of the directors, and also if they have the other conditions of the definition, if that is met, then typically control exists. And if control exists, then it is mandatory for filing of Form APR based on audited financials of the subsidiary or the overseas entity or the foreign entity. So the typical underlying factor is control. Then if control does not exist, then we have to look at two things. One is whether the host country has audit mandatory. If yes, then definitely you have to file based on audited financial statements. If no, then you have to look at the investor category, which is whether the investor is an Indian entity or a resident individual. If it's an Indian entity, then the unaudited financial statements of the foreign entity need to be certified as such by the statutory auditor of the Indian entity and not by any chartered accountant. And for others, where the investor category is a resident individual, it can be done by a chartered accountant. So now there are two nuances to this. One is that if there is control, if control exists and the host country does not have audit mandatory, then the requirement is to file based on the audited financial statements. There is no requirement that the auditor should be the statutory auditor of the Indian entity. So if there is an Indian entity who has invested in a foreign entity, the host country does not have a mandatory audit, the Indian entity can choose to get the subsidiaries' financial statements audited by any chartered accountant and not necessarily their own statutory auditor. And the second situation is where there is no control and there is an Indian entity and the host country does not have a audit mandatory requirement, then that overseas subsidiaries audit needs to be performed by the statutory auditor of the Indian entity. So I think this flowchart would help in determining where audit is necessary, who can perform the audit. So the next interesting question that comes up is that how is an Indian CA expected to know compliance of overseas laws and regulations? Should it only be the face of the balance sheet and the P&L, or should it be the entire set of financial statements? Also, which accounting standards need to be complied with? As to the books of account may be maintained following cash system, as audit is not mandatory. So how should the books of account be considered for the purpose of audit? And are these special purpose financial statements, which means that there's a specific SA 800 which governs special purpose financial statements? Well, I that this is kind of a professional judgment that needs to be applied, but my best guess or how we are doing it is to follow the special purpose financial statements with a fair presentation framework, and we either follow IGAP or Ind AS depending on the size of the entity and the applicable accounting standards in the host country. And that's how we issue a special purpose financial statement audit report under SA 800. So that's some guidance on how audit should be performed for these foreign entities. Who is required to file? Now, if there are more than one person resident in India, if two people have or two persons have jointly invested in an overseas entity, then the clarification or the requirement is to file by the person holding the highest stake. So if there are five people who have invested, but one holds the highest stake amongst those five, then that person is responsible to file Form APR. If there are equal holdings, say for example, four people have invested 25% each, then one, they can file jointly. Means they file one APR and they jointly sign on it and they issue it to the AD bank. And that joint filing can be considered to be filing. Any one could also file, but that has to be necessarily be authorized by the other investors. What happens to incomplete reporting? For example, you have filed form APR, but you actually missed to report any acquisition or setup of a step down subsidiary, or you missed to report any alteration in the shareholding pattern of the overseas entity. Then that filing will not be considered as a valid filing, and it would as it would be equated with a missed filing, which is non-reporting. What are some other nuances before we close this topic? I think there's not much about APR, but yeah, those are some technical points that we have discussed in this video. One very typical thing about APR is that all the reportings are cumulative, which means that when you have to report Indian holding, it means Indian across all the investors and not just you being the solo investor, kind of you reporting yours and then you don't say about the others. So that cumulative reporting requirement is very specific for APR, and all reporting needs to be in full figures. So if overseas financials are in rounded off figures, then you may have to multiply it by the rounding and take an estimate for that exact number. But APR reporting should be in full figures. And there's one important part about the statutory auditor or chartered accountant's certification of form APR. So one is the audit of the underlying financial statements, which is of the foreign entity, and the other is about the compliance with regulation 94 of OI regulations, which becomes a part of your certification of form APR. So as a Indian entity, it is required to get this certificate from the statutory auditor, and for the for a resident individual, a chartered accountant has to certify form APR. So this certification necessarily requires the certification of compliance with regulation 94, which essentially is the repatriation of any receivables. So if there is any liquidation, if there is any dividend declaration that is then done by the overseas entity, then within a period of 90 days, that is required to be received by the Indian entity or the resident individual. And this is a certification that the statutory auditor or chartered accountant is giving, which a professional should be mindful of. With this, we come to the end of this video, and we hope that you have received some knowledge out of it. And thank you.